Hello, my dear friends. I'm Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. So today's point of discussion will be a very important defense of law of tort, that is a plaintiff, the wrongdoer. If the plaintiff himself is at fault, he cannot take the defense of his own fault. So under such a circumstances, if the plaintiff is the wrongdoer, the defendant will be entitled to take the defense of plaintiff, the wrongdoer. So we will discuss all the examples and case laws relating to this defense in this lecture. So let's start the topic. Plaintiff, the wrongdoer is another defense available for the law of tort. For the tort, this defense can be taken by the defendant and he can avoid a liability by taking such a defense. So plaintiff, the wrongdoer is a defense available for the tort. We will discuss in what circumstances exactly the defendant can avail the facility and the benefit of this particular defense. Plaintiff, the wrongdoer. So no court will aid a person who found his cause of action upon an immoral or an illegal act. Suppose if the person's act itself is an illegal one, if the person's act itself is an immoral one, then no court will give any kind of benefit to that particular person, because the base for claiming the compensation, that particular base is immoral and that particular base is illegal. Suppose if I am at fault, then I cannot take the benefit of my own fault. Suppose if I have committed any wrong, I have committed any illegal act, by my illegal act I cannot take any kind of benefit. So if I am at wrong place and due to which I sustain a loss, though the reason of that particular loss is some other person, but I cannot claim a compensation, and if I filed a suit against that particular person, then that person is having a right to take the defense, and that defense is supposed to be known as the plaintiff, the wrongdoer. So plaintiff is at fault. Plaintiff himself is at fault. Plaintiff commits an illegal act. That's why defendant is having a right to take the defense of plaintiff, the wrongdoer. This particular defense is based on the maxim ex terpi causa non orisere actio, which means from an immoral cause no action arises. The very meaning of this particular maxim is, if the act of a person is immoral, then there will be a no action by virtue of that his immoral act. So means from an immoral cause no action arises. If the person commits an illegal act, if the person is having and committing an immoral act, then he will not be entitled to take action against the other person, and if he take, then other person is having a right to take the defense of plaintiff, the wrongdoer. The very good example of plaintiff, the wrongdoer is going wrong side. Suppose if I am going a wrong side, suppose if I am driving a car through a wrong side, and suppose other person had dashed to me. If you dash to me, I am at wrong side, you dash to me, I am driving a car and you dashed my car. Definitely, if I filed a suit against you, then you are entitled to take the defense of plaintiff, the wrongdoer, because being on a wrong side, it is my illegal act. So if I have to drive a car, I must drive a car with a right side. If I am driving a car with a wrong side, this act will be known as an illegal act. Suppose if I am at fault, then you will not be held liable for that. You are at right side. You dashed my car, no doubt. But plaintiff, the wrongdoer, this defense is available for you because I am at a wrong side. So I cannot take the benefit of my own wrongful act. Suppose if I am at wrong side, so I will not be entitled to take any benefit. I will not be entitled to take any kind of benefit from my wrongful act, and you are having a right to take the defense of plaintiff the wrongdoer. Bird versus Holbrook, this is a particular case relating to the defense of plaintiff the wrongdoer. In this particular case, plaintiff injured due to spring gun. So in this particular case, defendant has installed a spring gun in his premises for protecting his premises from a trespasser. So he fixed a spring gun, and when plaintiff tried to enter into the premises of defendant, plaintiff got injured due to that particular spring gun. Plaintiff filed a suit against the defendant because of that particular injury which caused to him due to the spring gun. So plaintiff filed a suit against the defendant, but in this case, the defendant took the defense of plaintiff the wrongdoer. In this particular case, defendant says that plaintiff entered in my premises without my permission, and this is a wrongful act, this is a trespass, and if the plaintiff himself is at wrong, then I am having a right to take the defense of plaintiff the wrongdoer. But in this particular case, court says that whatever the force you applied for protecting your premises, that force was excessive one. Definitely, you can protect your premises from the trespasser by applying a certain force, a approximate, proportionate force. But in this particular case, defendant installed a spring gun, and this was supposed to be declared by the court as a excessive use of private defense. So in this particular case, the court says that plaintiff the wrongdoer is not a defense available for the defendant because he used a force by installing a spring gun, and that is excessive one. That's why plaintiff the wrongdoer, that defense is not available for the defendant. Nullum commodum capre potest de injuria so propria means no man can take advantage of his own wrong. So another maxim, Latin maxim on which this particular defense was based, that is nullum commodum capre potest de injuria so propria, means no man can take advantage of his own wrong. So if my wrong is there, I cannot take advantage of my own wrong. If I am at wrong place, if I have committed any wrongful act, I cannot take the benefit of my own wrongful act. But the person against whom if I filed a suit, he will be entitled to take the defense of plaintiff the wrongdoer because I am at fault. Suppose if I am traveling through a bus and if I project my hands out of the window of the bus, and if the another bus dashed to me and if I got injured, definitely that particular person will be entitled to take the benefit of plaintiff the wrongdoer because it is my wrongful act, it is my fault. I am at wrong place because I project my hand through window, and that's why I got injured. So under such circumstances, defendant will be entitled to take the defense of plaintiff the wrongdoer. So plaintiff the wrongdoer is a defense available for the defendant, and when plaintiff the wrongdoer, this defense can be availed by the defendant if the plaintiff himself is at fault, then only the defendant will be entitled to take the defense of plaintiff the wrongdoer. Plaintiff himself committed a wrongful act and plaintiff cannot take the benefit of his own wrongful act. So that is a defense available for the tort, that is the plaintiff the wrongdoer. I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button and share this video with your friends. Thank you very much.